Hello, my name's Nicholas Watt. I'm a partner and attorney here at Kramer, Elkins & Watt, or Q. Today is going to be our first part in a five-part series on litigation. The first question to ask and answer is, what is litigation? What does it mean? A lot of folks ask me or seem confused about that term, and litigation is simply any dispute that has to be settled in court. So if you have to go to court to enforce your rights or defend your rights. So the first thing is what kinds of disputes could be considered litigation. Some of the common disputes that litigation would involve would be, say, a contract dispute. Someone promised to do something for you in return for payment. You've paid them, but they didn't do the work. That would be a litigation over a contract dispute. Say you got in an automobile accident and you need to enforce your rights or get payment for the injuries you suffered. That would be litigation. Say you own a small business with a partner. You and your best friend started this business on a handshake, and then all of a sudden you two don't see eye to eye anymore. And so you need to enforce your rights as a 50% owner of that business. Sometimes you would need to go to court to do that. That would be litigation. So it can vary from many different types of things. Again, estate planning. Say a sibling of yours has unduly influenced a elderly parent who's in cognitive decline, and you feel that that's impacted your potential inheritance. Again, you can go to court potentially to enforce those rights. So it does take into account a wide variety of different actions and potential claims. So what should you do if you feel you've been wronged? Well, number one, predictably, you should probably contact an attorney to discuss what your potential rights are, what potential claims may be out there for you, and whether it makes sense. Some attorneys will take a case that comes in the door. Other attorneys, and hopefully most attorneys, will discuss with you about discussing maybe how valuable your claim may be, or how costly it may be to go to court and to enforce. So there's a cost-benefit analysis that needs to be conducted. And a good attorney will go through that and say, well, this person owes you $50,000, but it's going to cost you $30,000 to file a claim and go to court. Can we settle for 25, 30 now and avoid the stress and hassle of litigation? That's something that an attorney can discuss with you before the claim is even filed or commences. But again, step one for you as a potential legal consumer should be to hire an attorney or talk to an attorney at least. Second, if you decide you want to go forward, if there's no statute of limitations issue, and a statute of limitations is a bar on your claim after a certain amount of time. So, for instance, with a contract dispute, if the claim arose 6 years ago, or more than 6 years ago, your claim is barred. There's a statute of limitations on a contract claim of 6 years. So if the breach of contract happened further than 6 years ago, you're going to be out of luck. If it happened, within the last 6 years, then you can still enforce your claim. If there is that time, the next step should be to send what we call the demand letter. A demand letter is simply a letter that your attorney would send to the potential defendant outlining the facts and claims of your situation and saying, listen, here's what's happened, and you outline kind of the facts of the situation. We had this contract. You didn't fulfill your obligations under the contract. You owe me X amount of dollars. Pay now to avoid litigation and the costs and stress and all the other things that go along with that. So if you have time to do that, that was kind of a first step pre-suit. And then you can kind of negotiate, because litigation is expensive, attorneys are expensive, and the process can take a while. If that doesn't work, then your next step is to commence an action. And your attorney will have to draft what is called a complaint. And that complaint simply outlines the facts, again, of your particular situation, and then outlines whatever claims you may have against the defendant, the person who's wronged you. So then you take that and you attach a summons to that complaint, file it in court, and then you have to have that summons and complaint served on the defendant within 90 days of filing. And usually you can use the sheriff's department or a private process server to officially serve the papers on the defendant. Once that's served, the defendant will have, depending on the type of claims that you've alleged, either 20 or 45 days to answer. And they will answer their claims, your claims, by either admitting or denying or saying essentially, I don't know, to each of the enumerated facts and allegations you listed in the complaint. Once that is done, the answer is filed, the action is commenced. It's also worth noting that the defendant may think they have claims against you, and so they can file something along with their answer called a counterclaim. And then you will have a certain amount of days to then respond to that. So that is how an action is commenced. After that becomes a long period of what's called discovery. There are different motions that can be filed up until and leading to trial. There could be mediation involved at some point during the course of the litigation. And then eventually you're going to go to trial. And then even after trial, it still may not be over because there may be post-trial motions or briefs or even an appeal that follows after that. And so in the next series of this litigation series, we'll talk about those different steps. So part 2 coming up soon will be the discovery. Thank you again for listening. Again, my name is Nicholas Watt, partner and attorney here at Kramer, Elkins & Watt, or Q. If you have any further questions about litigation or feel that you may have a claim against someone, feel free to contact us and visit our website at kewlaw.com. That's qlaw.com. Thank you.